This is part 2 of property. We're going to discuss concurrent estates. Concurrent estates are ownership or possession of real property by two or more persons simultaneously. These include tenancy in common, joint tenancy, tenancy by the entirety. Looking at tenancy in common, again, two or more grantees. This is no right of survivorship. This means that if one party dies, the other party does not get their interest. The party can pass their interest down to an heir. So each tenant can freely transfer their interest to anyone. Majority of jurisdictions hold that a conveyance to two or more persons, there is a presumption that a tenancy in common has been created. Tenancy in common, parties have an equal right to possess and or use. It's unity of possession. They are entitled to receive a share of rents or profits from a third-party lessee. So this is where one of the tenants in common leases to a third party and gets some income from that lease. The other co-tenants, or the other tenants in common are entitled to receive a portion of their profits. Looking at joint tenancy and determining the difference between a tenancy in common and a joint tenancy, you look to survivorship language. Again, a joint tenancy is conveyance to two or more owners. Look to survivorship language, such as it is indicated that upon death of one joint tenant, the other tenant gets their interest. So you can go from two joint tenants, one dies, now there's only one tenant. The intent in survivorship language, however, must be very clear. Joint tenancy requires the four unities. Joint tenancy must have unity of possession, that's an equal right to possess, and the unity of interest, that's an equal interest, unity of time, that means that both are created at the same time, and unity of title, that means that it is in the same instrument. You can sever a joint tenancy. You can sever a joint tenancy where one joint tenant conveys their interest while they are alive. This conveyance severs the joint tenancy. It makes sense because then a tenancy would still exist. Again, there is no unity of time. Right of survivorship is also destroyed, and the tenancy is converted into a tenancy in common. However, if there are three joint tenants and one tenant conveys their interest to another party, the remaining two joint tenants still exist in a joint tenancy. Example is A, B, and C exist in a joint tenancy. A conveys to X, conveys their interest to X. X, B, and C then exist in a tenancy with B and C as joint tenants to each other, and X as a tenant in common with B and C. In a joint tenancy, a lien against any one joint tenant terminates upon that joint tenant's death. This prevents encumbrance upon the remaining tenants. Mortgages in a joint tenancy, there are two theories. There is a lien theory and a title theory. But generally to mortgages in a joint tenancy, a joint tenant may grant mortgage interests on their property interests. Under the lien theory, which is the majority theory, it does not sever, it does not count as a conveyance, because in a mortgage the bank actually becomes a member of the deed. Under a lien theory, this is not a severance, it's only a lien in the property, lien on the property, and this does not sever the joint tenancy as a conveyance. Under title theory, which is the minority of jurisdiction, under a title theory, a mortgage is treated as a conveyance and it does sever the joint tenancy. Looking at leases, the jurisdictions are split. Some sever and some hold the lease as a temporary suspension of the joint tenancy. Looking at tenancy by the entirety. Joint tenants, this is a joint tenancy by married persons. They must be married when the conveyance occurs, and this is called unity of person. There is a right of survivorship in tenancy by the entirety, so one married couple dies or gets murdered, there is survivorship to the other, in the non-murdered individual in the marriage. Neither party can alienate or encumber, however, without consent of the other. Looking at rights and obligations of concurrent estates, they have the right to possession. Co-tenants have the right to possession, there's right to full possession. You may not place boundaries between two shares, and they are not required to pay rent to each other or share profits with each other. Again, that's different than if one of them leases to another party and gains profits. Ouster is a court action where one co-tenant denies access to the other. In regards to natural resources, each is entitled to the natural resources in proportion to their share. Third-party rents, as I stated earlier, must be shared, divided by ownership interest. Operating expenses, co-tenant may collect a contribution for excess operating expenses paid unless that tenant is the only one in physical possession and their value or use is equal to or greater than the overpayment. What this means is if one party is in possession of the estate, it makes $100 and they have to split it two ways. So this one party in possession would make $50, but they put in $40 for operating expenses. They then made $10. They can't go seek a contribution from the other tenant. However, if they put in $40 and they only made $30, then they can go seek a contribution from the other tenant. In regards to repairs and improvements, there's generally no right to reimbursement. Fiduciary obligation is not owed between co-tenants. There is, however, a duty of fair dealing. And an acquisition that affects the estate is considered an acquisition by all co-tenants. Partition is a court action to divide the property into separate and distinct portions. This is again different than ouster, where you oust a tenant. A tenant in common or a joint tenant has a unilateral right to partition. A tenant by the entirety does not. Again, tenant by the entirety are married people. If the property cannot be divided, the court can sell and distribute proceeds. There is a restriction on partition. Agreement among co-tenants not to partition is enforceable. And that ends part 2 of property.